Well, hello, friends. This is Uncivil Law. Hope you're having a great night, and we are here with our weekly Q&A, hangouts, answering questions, questioning answers, all that good stuff. All will be revealed with Uncivil Law. Yes. So we will begin, as always, with comments from Discord. Are there any comments from Discord this week? Let's see. Where's my weekly question? There it is. Okay. Okay, Kratos asked, now that the Toddy without a crystal ball stuff has simmered down, will you be watching KJ's channel to see some of the videos why some of us wanted Toddy to win so badly? Lots of people seem to have disappeared from the platform, including some of your mods. Is there a different platform you use or a secret society? So those are two questions that I will answer separately. As to watching videos from Without a Crystal Ball, no. I really have no interest in watching her content. And there's no reason for me to do it. So there's no reason for me to do it personally. And there's really no reason for me to do it professionally, because watching her content could only skew my perspective. The court is not going to look at her videos that early on in the case. It's unlikely. It's very unlikely. And I would bet dollars to donuts the court didn't look at a single video at any point in the case. I mean, I couldn't say for sure, but I doubt it, since they had other issues to deal with, right? So Toddy without a crystal ball might come back. As I understand it, last I heard, they were in negotiations to settle. So I don't know what that result will be. And if it comes back, I'd like to remain unbiased. And even if it doesn't come back, it might taint my perspective going into the future in some ways. So I think it's probably for the best that I try to remain out of it. I understand a lot of people don't like Without a Crystal Ball. I fully appreciate that. If I watched the videos, maybe I wouldn't like a crystal ball. But that would only at best skew my perspective. So I don't see what I gain from watching it that would make it worthwhile. So yeah, maybe she's a truly horrible person, but the law protects horrible people too. So that's, and as to some people leaving and the mods leaving, there was some turmoil that has been solved. There's no secret society, no other place we hang out. So this is it for the moment. So we'll see. And then Botanic said, thoughts on Florida's social media law? Against the conclusion of everyone else, in my opinion, it's constitutional. It seems everyone's hanging their hat on Miami Herald publication versus Toronalo. But the part that turns the case for me is the Florida statute exacts a penalty on the basis of the content of the newspaper. Seems the Supreme Court is saying it's not equal. That's a problem. In Florida, it's equal. In closing, Scottus mentions the right of the editor to make decisions as a major factor, but under Section 230, if you're the editor, then it falls outside your protections. And they've been arguing hardcore they aren't editors, so they can't fall under Miami's Herald logic. I don't know enough to know for sure, but I'm assuming it will be tested, and I would be skeptical of its constitutionality. I'm sure Florida thought ahead and thought about these issues, but whether or not they're successful, only time will tell. So we will see how that goes. And that is all the questions for today. Yeah. Tedo Kokian C says, can a pro se litigant be held in contempt? Yes. If acting pro se, one should refrain from mocking other attorney in social media. Probably for the best. Now, courts will tend to give pro ses a little more slack, but even though they give them more slack, the pro ses have a tendency to go well off the reservation. But yes, anyone can be held in contempt. And then the court will give warnings, but yeah, don't be an ass is usually a good rule. Can defendant in a contempt hearing turn tables on the person bringing charges? I don't understand the question. If you're asking in a case that is brought by the prosecutor for contempt, can the prosecutor in that hearing be held in contempt? Sure. because it's another hearing before the court. So if you're asking if there's a criminal case and the case is contempt, can the prosecutor in that hearing be held in contempt? Sure, if they're in contempt. It's a hearing like any other. So contempt charges can come out of contempt cases. There's no reason for them not to. So all that good stuff. All right. Now we have some comments from prior stuff. In response to the reaction to Last Week Tonight, which I'm happy to say is outside of HBO's copyright domain because I protested, so it is available for you to watch if you didn't see it the first time. John Oliver only cares about stand your ground laws because the media lied that George Zimmerman, that's with the Z, but fair enough, was using stand ground on Florida as a defense. He actually used the state's use of force self-defense statutes written. That's true, right? Yeah. Stand your ground or not didn't really come into play. Because his head being bashed in the concrete sidewalk counted as deadly force regardless of stand your ground. Right. So it wouldn't matter either way. Nothing that led up to the assault mattered once Trayvon was on George smashing his head. You don't get to defend yourself like Trayvon's supporters claim and then use excessive and continuing force, especially deadly force, when nothing at that point substantiated Trayvon doing so. George was also unable to retreat at the time of the deadly force. Correct. If he was already under attack, he can't retreat. So standing your ground wouldn't matter either way. But because the media lied about the entire case and made up the term white Hispanic, which was hilarious, now every progressive is supposed to hate stand your ground, even though it's the only thing that makes constitutional sense. I'm not sure if it's the only thing that makes constitutional sense. The alternative makes constitutional sense. The right to keep and bear arms doesn't imply, I don't think, one or the other. The Second Amendment is about the right to self-defense. If we have a duty to self-retreat, then we have zero safeguards for self-defense. That's not true. You still can exercise self-defense in a duty to retreat state. It just changes the circumstances under when you can use them. Maybe for the worse, but it's not correct that you have zero safeguards. There are valid self-defense cases and duty to retreat cases either. So that doesn't flow. You blink click in chat points out what leads up to assault does matter. You can't instigate a fight and claim self-defense. That's true. Fair correction. Yeah, so you have to be a good actor. You can't be a bad actor and take advantage of self-defense. So yeah, what leads up to the fight is correct. I suppose I didn't make the correction because I was thinking about the actual Zimmerman incident, but I should have thought more broadly. So I appreciate the correction. If you're a bad actor, if what leads up to the fight is you being the bad guy, then yeah, you can't take advantage of self-defense. In response, the police are not required to protect you. I think the English interpretation of tort of negligence would have covered this. By responding to the call, they assumed a relationship to the woman and an obligation to act. I couldn't speak to English law, although I would be doubtful because there's nothing in the common law. So unless such an obligation developed in England after the U.S. separated at some point, which I suppose is possible, but I wouldn't know for sure. At least in the U.S., there's no obligation. I was having this disagreement with another person on the channel about the duty of a paramedic. And I was saying, okay, what would be the liability if the paramedic just doesn't show up? Or what would be the liability if the paramedic, once having arrived, decided, you know what, no, I'm not going to do anything, and noped out? And as far as I can tell, there's no liability, because the paramedic doesn't have duty to act under the stand, unless there's some law to the contrary, and I couldn't find any specific law. So, because the paramedic doesn't have any sort of relationship to the person, there's no contractual relationship, there's no familial relationship, so the paramedic, at least as far as I could tell, could get the call from 911 and be like, I'm just not going to go. And I can't see how you could sue the paramedic unless there's some specific state law that applied, and I couldn't find any. So I'm still waiting to see if someone can show me a specific. So the hypothetical here, just so we're clear of what to search for, let's make it easy. Let's suppose someone calls 911, dispatches the paramedic. Let's suppose the paramedic even begins to go towards the scene, and at some point the paramedic decides, I can't be bothered to care. Maybe goes into the 7-Eleven and gets an ice cream. Can you either prosecute or sue the paramedic under any law? I say no. If you can think of yes, please cite relevant legal authority. I'd love to learn something. What's the taking on the passing of constitutional carry? Did it actually pass? Last time I heard it was in negotiations, but that's okay. I might have missed a memo. Let's take a look. Apparently it did pass. Okay, well, there you go. That's something new. So, yeah, so Abbott said he'll sign it into law. Great. And the House approved a deal. Great. So I don't need a license. Excellent. Fantastic. Okay, so they removed a provision that would have barred officers from questioning people based only on the possession of a handgun. So officers can question people on that basis, I suppose. I'm not sure what questions would be, but, whatever. And there is an enhancement to criminal penalties for felons and family violence offenders get caught carrying. And there's a requirement Texas Department of Public Safety offer a free online course on gun safety. Presumably you don't have to take it, but they have to offer it, which is fair enough. So I'm perfectly happy. So let me know when it passes. Maybe I'll go out and carry just for the hell of it. Could be fun. Eledian says, so Zimmerman should have been convicted because he's barred from lawful self-defense? Should have been barred? No, because at least according to Zimmerman, and what's true in reality, who knows? But at least according to Zimmerman, he wasn't doing anything illegal. And he didn't start the fight. What Zimmerman said happened is that he saw Trayvon Martin walking through this property or this neighborhood and thought he might be up to no good. And so he proceeded to follow him. And there's nothing illegal about following somebody. Now, 911 told him repeatedly not to, but again, 911 saying to do something or not do something doesn't make it legal or illegal. Now, I probably was advisable for 911 to give that advice, and probably was advisable for Zimmerman to follow that advice, but he's not compelled to. So the way Zimmerman tells the tale is he went out and he started looking for Trayvon Martin because he was curious if he was up to something. And then Trayvon Martin surprised him and started beating the crap out of him. So Zimmerman, at least according to his story, didn't do anything he didn't start the fight. He didn't start the conflict. He didn't do anything illegal. So no. He started the fight. The 911 operator told him not to pursue. Yeah, Eledian. But the thing is, the 911 can't order you to do anything any more than the police can. Like, the police can't just arbitrarily make something illegal, and they can't arbitrarily make something legal. So 911 saying don't do this or do this, it's like, well, I'm appreciative of your advice, but you don't get to command me because you don't have the ability to command me. Either there's a law in operation or not, right? So 911 saying don't do this, I'm like, well, I'm gonna do it. I'm appreciative of the advice, but screw you, 911. That's perfectly fine. A Hanger said, did he pursue or did he start to fight? Again, way according to Zimmerman, the way he told the tale is he was following Trayvon Martin, and Martin surprised him, and Martin started the fight. That's the way that Zimmerman tells the tale. And we don't just have to take his side, because there's all kinds of evidence from which a jury could draw the opposite conclusion. There was Zimmerman himself, his statements he made. There was the autopsy. There was statements from other potential witnesses, character people. So you don't have to believe him. That's why we had a trial. It's almost like we had a trial and the evidence was put into place and the jury thought, no, I can't find proof beyond a reasonable doubt, which is almost certainly the correct conclusion. Even if you think he's likely guilty, that's not the standard. Can you get the proof beyond a reasonable doubt based on the collection of evidence the government had? In my humble opinion, no. I don't think you can get there. It wasn't enough. So, you're not forced to believe him. You can disbelieve him, but then again, he doesn't have to convince you of anything, right? The government has the burden of proof. So it's not whether or not you believe him or not, it's whether or not you believe the government or not, and whether or not they've met their burden of proof or not. So you can disbelieve Zimmerman completely and still be like, well, the government didn't prove their case, so not guilty is the correct answer. So, believing Zimmerman would make it easier to draw that conclusion, but it's not necessary. Do you think the heartbeat law signed by Abbott in Texas will be overturned? Well, it's hard to tell for sure. The Supreme Court just took up that case from Alabama, I think it was, where they did the 12 or 15 weeks. I don't remember, nor does it really matter for the purposes of this exercise, because either one is below the threshold I think that the current law gets you for. So the Supreme Court's going to answer that question sometime in the upcoming session, well, directly or indirectly. So I don't know. If I had to guess on if you said on the state of the law right now, will they win? No. Neither will Alabama or Mississippi or whatever it was. But either way, there's a reason the Supreme Court took the case. So is the Supreme Court about to modify the law? I don't know. Maybe, but under the state of the law right now, no, it won't survive. So we'll see what happens. Alabama, yeah, it was one of them. It didn't matter. A state, whatever. In response to going live on Thursday with the latest update in Haley Page, will there be cake, wedding cake, and tea? Well, you're a member of the channel, Sledge and Widge, so you can check yourself what all the things have to prove. Yeah. Investigating a bank robbery in the wee hours of the morning. Banks are not open at that time and therefore unable to be robbed. No. No. Just because the bank is closed does not necessarily preclude it from being robbed. Presumably, it makes it harder, but not impossible, depending on the bank in particular. Not all banks are really fortresses, so that you could at least try. But yeah. Faye O says, Texas, I believe, is the only state that allows deadly force in defense of property in limited circumstance. I think that's a significant factor for Mr. Horn in response to the shooting with Mr. Horn. Okay, I was vaguely aware of that, but let's take a look and see if it influences the analysis of Mr. Horn. So the Mr. Horn case we discussed during last week tonight, and the reality, or at least based on what we understand so far, Mr. Horn observed burglars at his neighbor's house. Mr. Horn, against the advice of 911, went outside of his house with a shotgun. And Mr. Horn shot them as they might have been coming to them. And I think he might have shot them in the back. So let's see what the relevant law says in response to this. So here's what section 9.41 does. So protection of one's own property. A person in lawful possession of land or tangible movable property is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate the other's trespass on the land or unlawful interference with the property. A person unlawfully dispossessed of land or tangible movable property by another is justified in using force against the other when and the degree to the actor believes force is immediately necessary to re-enter the land or property, if the actor uses force immediately or in fresh pursuit after the dispossession, and the actor reasonably believes that no other has claim of right, and the other accomplished the disposition by force, threat, or fraud. So you can use force to the degree necessary to maintain your land or get it back. So that might have had some influence in the Horn case. Now, I'd like to take note here that it doesn't necessarily allow lethal force on its own terms. You can only use force against another when and to the degree it's immediately necessary to prevent or terminate the other's trespass. So I don't think shotgun automatically comes into play, but fair point. Melissa Boomer of the Night says, your dry manner makes us laugh. My husband and I enjoy and respect you. Well, thank you, Melissa Boomer of the Night. I'm glad you enjoy my humor. I'm glad that someone appreciates me as I am. Not a legal question, but I have to drive to DFW from Victoria. Is Austin still a mess on I-35? Depending on the time of day, yes. Eledian says, I forget what state it is. The sole state where defendant has to prove self-defense on a preponderance. Ohio. Yeah, Ohio would be the answer to that question for some reason. Stephanie's here. Hello, Stephanie. John Harrigan says, I don't have to flee if someone else is facing great harm. That's the extent of stand your ground. It's really standing someone else's ground. Well, it's not really stand your ground that's popping up here. Rather, it is defense of others. So stand your ground or not is not really the equation here. And whether or not you're standing in the shoes of someone else, I wouldn't know without reading the law specifically, because sometimes it depends. Okay, this is interesting. All right, so some of you haven't seen this video yet because it's not being released until Thursday. So I have to explain this reference where it says the pound me too was too much. Goodbye, y'all. Okay, I have to explain this. So, like, it's about halfway through the video, maybe a little bit more. But someone commented, and I had never thought about it before, and I even made a note of saying I never thought about it before. But someone in the live chat made a point of saying how #MeToo could be read as pound me too. And so I made a note of that too. It's like, oh, I'd never thought of that before, but you're right. #MeToo could be read as pound me too, or for that matter, sharp me too. But I made a note of it that I had never thought of that before, and I was like, you get a bonus point because you made me think of something I hadn't thought of before. You've increased my knowledge or increased my ability to think. So it was an interesting observation. I never thought about it before, so someone mentioned it. I did too, and apparently that was too much for this one person. So whatever, what can you do? Octothrope me too. Secret Service versus U.S. Park Police. If they're willing to do this to a known Secret Service agent, what would they do to a civilian? I don't know. I don't necessarily know what they do to a civilian, but it could just be a pissing match with a rival police force. So I'm not sure you can necessarily conclude, although it would be a fair conclusion. It'd be a fair conclusion that they would do this or worse to a civilian. But I'm not sure it's the necessary conclusion. It could be a jealousy thing or an envy thing. It could be we want to flex over someone else who thinks they're better than us. So it could be that kind of thing. So maybe they wouldn't do this to a civilian, but they would do it to the Secret Service, specifically because they're envious or because they want to give them a hard time or show that they're the boss and it's their domain kind of thing. So I don't know. But either way, it's a point worth thinking about. Chuck Keyworth says, did you break someone? Apparently. And A. Henninger says, yeah, I think it was an interjurisdictional pissing match. That seems the most likely conclusion. So I'm not sure it necessarily follows that the U.S. Park Police would have done this to a civilian. I think it was some sort of pissing match because the Park Police have an inferiority complex. It's like, this is our park. You're in our park. In response to the Capitol riots, number 53, do you have the video of the Google exec who was there and the one of the Antifa changing clothes into Trump gear? I don't know. I'm not familiar with those videos. And to the extent they exist, the only way I'd find them other than being given them would be doing a Google search, which I assume you're equally capable of doing. So no, I don't have the videos. I'm not even familiar with the videos you're talking about. So I'm not going to do the search for you. If you happen to come up with them and you want to share them with me, that's fine. You can always tag me with the videos on Discord. But I don't have any special powers to search more than you do. So go forth into the world and see if there's videos there and, fine. In response to number 53 of the Capitol riots, another great episode. Maybe Milkshake can share a cell with Double O Dipshit. My milkshake brings all the boys to the yard and they're like, it's better than yours, damn right. It's better than yours, I can teach you, but you have to judge. La 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 la. In response to the 4 officers put the knee on the neck, which was not George Floyd related, I love learning from the misfortunes of other great video. I'm glad you like it. In response to the arguing with Reddit is pointless. I get into these kind of traps on Facebook groups too. It's so frustrating to see how many idiots there are. It surely is, especially as you're trying very hard and it's not going well. I wouldn't say arguing with Reddit is a complete waste of time. I, for one, found it very entertaining, and I got a few laughs out of it. Thank you. Yeah, there was some benefit at the end of the thing, but it was not pointful unto itself. So unless you're planning on, creating content from it, and I'm not sure I would do it deliberately because I'm not sure it's worth the mental pain. But, why do people who aren't lawyers think they know more about law than actual lawyers? That's an outstanding question. I don't know. Especially the sovereign citizens. They're the worst because they think they know more about law than literally every lawyer and every judge. We're all wrong. All of us. You'd be hard pressed to find a lawyer or a judge who believes in the sovereign citizen stuff. Because for starters, why would they be a judge if they believe in sovereign citizens? That's a good point. And what lawyer would believe in it? There's probably one who's crazy enough out there, but, it's a small, far and few between. So when basically every lawyer and every judge is telling you, in this country and other countries for that matter, you're wrong, but the sovereign citizens keep the hope, man. They're like, no, I know better because I have Black's Law Dictionary. I know about the Magna Carta. That was good. Where do you even start? You don't. It's a waste of time. In response to Attorney Tom joins the happy hour, I was told there are no stupid questions, just stupid people. Then I was called a moron. This was good, yeah. In response to arguing with Reddit is pointless. Tamara Holloway said, I'm really want to watch. I tried, but 10 minutes into his stupid is just too much. Uncivil, how do you get through the whole thread? And then Tamara Holloway responds to herself, as I wrote, it played in the background. My head about exploded when there's rebellion and insurrection, but not insurrection itself. Yeah, there's no crime called insurrection. There's only a crime called rebellion or insurrection. So there's no crime called insurrection. And those are materially different. Okay. Yeah. Ublex says you should do an analysis of the boogie charges. Make sure you evaluate all the relevant legal statutes. Maybe I will. That's a good thing. I could do it for some clicks. That'd be good to get in there and try to cover it. I'd have to really dig into it and try. I guess it could be the first of our true crime series, the boogie incident. True crime, boogie, and discuss what he's guilty of or not. And it's probably likely that he's guilty of something. So we'll see how it develops, but yeah. Castle Doctrine in Arkansas. I don't think Castle Doctrine is going to impact it either way, to be quite honest, because he came out of his house and he went into his property and then shot a firearm in the air. So he went into a known confrontation. I don't think Castle Doctrine, unless Castle Doctrine is, well, actually, I did read the Castle Doctrine statute, and I don't think it's going to impact the legal analysis one way or another. If he had busted down the door, sure, but he didn't bust down the door. Boogie went outside of his door and fired a firearm when he didn't have to. So I'm not sure about that one. Also, the fact that he fired up into the air rather than at him might doom him, because Castle Doctrine protects you in the use of lethal force. But Boogie didn't use lethal force. He shot up into the air. He didn't even try. His intent wasn't to use force against him. So, for example, I don't know if this is the law now, but I remember reading a case from the Supreme Court of Kansas, I'm pretty sure it was, where a person, just to show you how stupid it can get sometimes, I remember reading a case from the Supreme Court of Kansas where a guy had the absolute right to use self-defense. And what he did is he pulled out his firearm and he only pointed it at them. And then they left. Okay? So he didn't fire, right? He had the right to self-defense. He pulled his firearm and he didn't fire. He was charged and convicted, and the Supreme Court of Kansas upheld the charge. Now, I can't remember exactly what he was charged with or convicted of. Maybe it was brandishing, maybe it was assault with a deadly weapon or something. But the Supreme Court of Kansas interpreted their own statute. It's like, well, you have a right of self-defense, but you didn't exercise it right. All you did was pull out the firearm and brandish it, which isn't the same, so you don't get the legal protection. I don't know if that was overruled by statute or not later, but I remember that case because it pissed me off. In response to the Capitol riots, I'm guessing they mean a photograph taken by a photographer as opposed to one from a security camera. That's the only reason I can think to specify the photograph was taken by a photographer. Reasonable. You get a little heart. Yeah. In response to arguing with Reddit, recalling the old movie Paper Chase, which is a pretty good movie about law school, although it's a little outdated for law school these days. It really focuses heavily on the Socratic method, and that's a little less popular. When I went to law school, I had one teacher who was really into it, and the other teachers not so much. But anyways, it's kind of an interesting movie about law school. Recalling the old movie Paper Chase, a certain law professor said, "You teach yourselves the law, but I train your minds. You come in here with a skull full of mush. You leave thinking like a lawyer." Wow, that's a bad slip of the tongue. Wow. It's a good line and a good movie, but today, Uncivil found out what happens when you have a skull full of mush, meets a lawyer, and the results were not pretty. That is definitely true. Reddit, never will you find a more wretched hive of scum and autism. That could well be, for sure. In response to lying officers get owned by the Court of Appeals on the QI claim, every single one of these cases, there was a perfectly reasonable course of action they could have taken and chose not to. You're exactly right. That's pretty much true of that's true of the vast majority of cases. Usually, a case exists because someone took an unreasonable course of action. Usually, when a correct course of action existed. So that's pretty much true of all cases. We only go to court when things go wrong. If you take a reasonable, responsible course of action, you'll probably be fine. That's a good rule. It's like, it's like some people who say, I need to know exactly what the law is. Why don't they tell me exactly what the law is? I'm like, if you just do something that's objectively reasonable and you're not a dick, you'll be fine. You'll be fine. It's fine. And unless and the only other time that you'd really have to worry about the law is if you're trying to do something really specific that you need to know the law for. Like, I'm opening a business. Well, you probably should know that there's some laws that's going to be involved. You probably know that you need some kind of permit. You need some kind of license. You may not know exactly what you need, but you need something. So could you go look into it then? Otherwise, just don't be a dick and do something objectively reasonable. You'll be fine. Any chance you want to discuss the Marion Hammer cases for concealed carry? The actual case of Marion Hammer? I don't know anything beyond what John Oliver said, so I couldn't really comment about it intelligently. But whether or not Marion Hammer's case is a good case on point for concealed carry or not does not mean, or apologize, stand your ground, because that's what they're talking about. Whether or not Marion Hammer's case is a good case for stand your ground or not, there are other cases that are good cases. Like, if you want me to get you a list of all the people who are currently in jail in duty to retreat states that would not be in jail if they had a stand your ground law instead, then I guess I could theoretically do that, but we all know that there's lots of them that exist. And so the question is, well, do you want those people to be in jail or not? And I'm like, well, no, I really don't. So as far as I'm concerned, they're all miscarriages of justice. So, yeah. In response to the 4 officers put a knee on the neck of a handcuffed suspect lying on pavement, they obviously believed he was faking. That's why they did the sternum rub. Sure. Yeah, I'll be happy to do that. Give me a second. Hold on one second. Yeah, okay. So per a request from one of our members, I'm going to talk a little bit because one of our members may need a bone marrow transplant. And so I'm going to post a link for an organization that will allow you to do that if you're so interested. So there's an organization called Be the Match. And as the name somewhat implies, they do testing on you to put you into a national database that, if someone is a match for you, would allow you to do a bone marrow transplant. Now, obviously, I'll state the obvious, you don't actually have to donate at the end, right? You're only in the registry. So if you don't want to donate, you don't have to. But one of our members may need a bone marrow transplant, and so I wanted to put that in the link. So if you are so inclined to potentially be a match for someone, you can sign up there. I think they send you some sort of kit in the mail. I think you might spit into it or something. I'm not sure about the exact details, but I think it's fairly non-invasive. And then they put you into a database, and if you match, they'll let you know, and then you can decide whether or not you want to go through the match or not. So it's a option that's available to you. And my understanding is that bone marrow has to match pretty precisely. I think there's like, maybe I misunderstand this, or I'm getting this slightly technically wrong. I'm not a doctor. Give me a break, right? But I think it's like there's a couple key factors where it really has to match, and if it doesn't, it's not good. And you need like 18 of these 24 criteria or something. These numbers may amount to be correct. You get the idea. And it's actually pretty hard in a lot of cases to find it. So you can have, some bone marrow people can't find anyone in the database, even though the database is huge, because you need to find these really tight matching criteria. So just an FYI, if you're interested in registering for Be the Match for a bone marrow transplant, the link is pinned. So, yeah. I'm going to keep this up. Was the original trial issue in favor of Williams or officer? In front of the lying officers get owned? The trial decision was in favor of the favor of the defendants, as memory serves. But yeah. Okay, this will be interesting. Nathaniel Radin says, I continue to say this forever. Police should not be allowed to testify. It's prejudicial. They have a vested interest in lying to the courts as more convictions lead to promotions. I'm not sure if that's true or not. They've been shown to lie so often they should be considered less reliable than a lie detector. Ouch. Instead, officers should either be forced to gather evidence that does not rely on words or memories for everything they do. Having a number of good cameras operating on each officer at all times is cheap, easy, and might add a few ounces to their weight. Far less than that fourth or fifth mag. Well, that's one of the reasons body cameras are such a good idea, and one of the reasons that body cameras are helping to convict a lot of people who should be convicted of, and a lot of people, innocent people, go free. So body cameras are doing both. So that's good. One the shoulder, one the forehead with a 760-degree fisheye, one their back, and the barrel of a taser and firearm. 4K, 240 FPS. Do you know how much data that is? 4K, 250 FPS. Do you know how much data that is? Needs around 15 MA per minute to run and exists on every smartphone there is today. A system that can't be turned off and records at 4K, 250 FPS, 10 hours, we need 800 milliamps, or about 8 watts of power. Yeah, but the bandwidth and storage requirements, man, come on. And honestly, if we're worried about the weight, they should actually pay attention to the radios. It's so easy to build a radio system that operate on a bunch of networks meshed together, including talking to a cell phone, a car which could have a high-power relay in it, and other handsets. But instead they operate on non-digital radios that use tech older than anyone today. I really couldn't speak to the radio thing or the problems therein, but yeah. Eledian says 240 FPS. Wait, why? I don't know. It was their idea, but it seems very unnecessary. I'm not sure why 30 FPS is not enough for this guy, or even less than that. It could be 15 FPS. But no, this guy wants 240 FPS in 4K. I don't know, man. That seems... In response to lying officers get owned on the Court of Appeals on qualified immunity. I feel like you have no business saying whether or not the kids were stupid. You have never had legitimate fear of the police as a black man. Well, that I was saying they were stupid long before they got to the police. Because remember, one of them was concealed carrying and didn't have a permit. And that's stupid. So one of them was stupid well before they got to the police. So, yeah. If I were young and black and male, which we misspelled, I would be terrified of the police, terrified they pin on me and shoot me exactly like what happened, whether I'm innocent or not. Okay. The rate at which black men are shot by the police is much, much less than the media would lead you to believe. If you want to talk about the total number of times that police shot an unarmed black man, you're talking like less than 10 cases a year. It doesn't happen. It's the stats, the news media would make you think it happens all the time, but the stats don't bear it out. The stats, if anything, last time I checked, and it's been a while, but the stats seem to suggest that it's a little bit over-inclusive for white people versus black people. But when you do all the ratios and stuff, but it's been a while since I checked, so that might not be correct anymore. But either way, it's really very low. The number of times that the police unjustifiably shoot somebody is pretty low. So I don't think this fear is really grounded in anything. Now, if you want to talk about the police harassing you in ways other than shooting you, I'm more sympathetic to that because there's a better cause of action, right? So if you want to say, like, the police are stopping me more often or harassing me more often, then I think you have a better case. Although I still want to see numbers. But the police shooting you is just not borne out by the details. Yeah, standard movie format's 24 frames a second. It works great. I'm going to guess the police have never been anything but lovely and polite to you. That's probably true. I'd be very surprised if the majority of black people in this country would say the same thing for interactions with police. Even asking for help, haven't you seen enough cases already to know complying with the police when you're black is not a guarantee of safety? Nothing's a guarantee of safety, but it usually goes better. That's actually what annoys me about a lot of your arguments. You don't look at things as they really are. You bury your head in the sand and pretend that people comply with the police are automatically treated justly and fairly. No, I don't think that's true, but I think the amount of times they're treated unjustly or unfairly is less than might be suggested, and to the extent they are, I'd be happy to protest along with anyone else. Maybe that's happened in your world, but I'm going to guess there are a lot of people in this country who disagree with you. Well, they're absolutely free to disagree with me if they like. All right. The totally uncontroversial legal happy hour. Started out good, but not enough facts about Palestine here. Okay. I believe there is some bias due to American reporting. That's possible. And there are definitely some misstatements. I'm looking at you, Nate, with the 96% of what they want. Not accurate. Look up what Clinton meant by 96%. And if you're not well-versed, as you literally said, then stop talking. The analysis went downhill fast. Well, I'm fairly well-versed, although I could be more well-versed, but I know a decent amount about the Israeli-Palestine conflict. Like, we both knew about the quote from Clinton, right? And we both knew about the issue here, and we both knew about some major events in the past. So we both got a generally good idea of the Palestine-Israeli conflict and from various exposure, although, to be fair, I'm not infinitely well-versed on it, so fair enough. But in either case, I can have an opinion, and my opinion is I'm pro-Israeli. I think the Israeli government is a government that I support, and I think that if they are being shot at as a sovereign state, they have the right to defend themselves like every sovereign state. The Israelis do not recognize the Palestinian state, nor do the Americans, for that matter. So as far as both the Americans and so far as Americans and Israel is concerned, there is no Palestinian state. So that means that Israel, as far as we're concerned, or as far as we should be concerned, as far as Israel is concerned or should be concerned, they have the right to police within their borders. It's their country. They have the right to, one of the definition, the classic definition of what a country is you have a permanent population, you have a territory, and you have the ability to police your territory and control your borders. That's like the short definition of country. So, as far as I'm concerned, Israel should be allowed to respond to ongoing rocket attacks with responses in a military response. That seems like if it were happening in the U.S., I think we would have the ability to respond no matter what they call themselves. And I do not support Hamas in any way because I think that they're a terrorist organization. So there's all that. And I think that the Israelis act with as much care as is possible, and I think the Palestine forces do not. When the Israelis respond and they hit civilians, it's because the Palestinian forces have put their assets in civilian areas. So then when you're targeting those areas, which you have the right to do, you hit civilians, and you're like, oh, you killed civilians. Yeah, it's because you put your missile thing right in the middle of a civilian area. So whose fault is that? So yeah, I used to be, when I was younger, I used to be a little bit more balanced. I used to be a little bit more even-handed, and these days I'm like, screw it. The Israelis should have their entire territory. They should retake the West Bank. They should retake the Gaza Strip. They should control all of Israel, control all of Jerusalem, so forth and so on. So, that's where I'm sitting these days. Not for the least of reasons that I think they are a government that fundamentally shares our values, and most of their neighbors not so much. So, yeah. Yeah, and then Eledian says, but they should have fully annexed the territory. Israel's going for some sort of neo-colonial half measure. Yeah, they're going for some sort of half measure. They pulled out of the West Bank like 15 years ago, which was a mistake, in my humble opinion. And they're going for half measures, but at this point, let's quote Mike Ehrmantraut from Breaking Bad. The thing is, I did a half measure when a full measure was necessary. No more half measures. So, yeah. If Israel retakes all of Gaza and all the West Bank, then they have to give citizenship to the people living there, meaning Israel ceases to be a Jewish state. I don't know if that necessarily follows or not. Just because they live there doesn't necessarily mean they could have citizenship. I mean, every country gets to define citizenship according to its own terms, right? So, I mean, yeah, to put it quite plainly, we have non-citizens living in the United States, right? Just because they live here doesn't make them citizens. And when we annex territory, it doesn't necessarily follow. So I don't know what Israel would have to do in terms of that, but I think Israel gets to define who is and is not a citizen of their state. So they aren't necessarily compelled to say, well, these 1.8 million people who are not Jewish are Israeli citizens. They could be like, nope, they're not citizens. They're, permanent residents, but not citizens. Israel gets to define its citizenship any way it wants, just like every country on the face of the earth. So, yeah. Yeah, A. Hanger has it right. Canada started launching rockets into Wisconsin. I'd expect us to take out the launchers, even if they're in the middle of Quebec. Yeah. Would you basically make Israel an apartheid Jim Crow state? No, I don't think it necessarily makes them apartheid or Jim Crow again any more than the U.S. is an apartheid Jim Crow state. Again, as I just said just now, the United States has a significant population of people living in our country who are not citizens of the United States. Depending on how you count the numbers for illegal immigrants, for example, the United States has somewhere between 12 and 15 million people who are not citizens of the United States. I don't think that makes us an apartheid state just because we don't grant them citizenship. They're on our territory, but they're not citizens of our country. I don't know where you're not citizen of, but you're not a citizen of my country. So I don't think that makes you an apartheid state because you say, well, these people are not citizens of my country. They do not believe in the core values of our state, which I think is fair. So, so I don't really see that. Qualified immunity shouldn't apply where there's a conflict in facts. Qualified immunity applies if there's a conflict in facts and, all right, how do you say this properly? When you're looking at qualified immunity, you're looking at it from the perspective of the person who was harmed, the non-police side. So if the non-police say a series of facts that would prevent qualified immunity, you should believe their side. So that is the state of the law as it is now. Qualified immunity, if the conflicts of fact don't matter, they don't matter. So you assume, like every motion to dismiss, you assume everything the other side says is true. So if there's a conflict of facts, the only question is, well, there can never really be, strictly speaking, a conflict of facts. Technically, there can never be a conflict of facts because the only facts you consider are from the one side for the purposes of the motion to dismiss. So you only ask if their facts are true, do you win? Or can you win? And if the other side has the same facts or not, it's kind of irrelevant because that's how it works on motion to dismiss. All right, I'm going to stop doing some Q&A and I'm going to switch to doing stupid legal hypotheticals. And for this purposes, I'm going to steal from Attorney Tom subreddit because I can. So we're going to go to Attorney Tom's subreddit and we're going to respond to legal stupid or legally stupid questions. And we will give the best answers we can to stupid questions. How fun. Should be good. All right. Could I sue in this case? Say hypothetically your parents were making you do work that they directly profited from, but you didn't get anything. Could you sue? And let's say hypothetically you're a minor, say 14 years old. Could your parents get any legal trouble? Specifically, if you know what Canadian laws would be broken. Well, I can't speak to Canada, but I would imagine, without knowing for sure, it would be the same rule as the United States. And that answer is, yeah, your parents can make you do work, like chores, and even more beyond that. That was in antiquity the classic reason to have children, right? The children are a source of labor, right? That's one of the reasons to have children, at least in antiquity, is a source of labor. So yeah, you can make them work the field. That's also one of the reasons that the American school year is the way it is, because the children are needed to work the field. So yeah, your parents can make you do work. Now, these days, there are limits on what that looks like. But yeah, sure. If you're 12 years old and they make you work in mom and dad's store, yeah, that's probably fine. And they don't have to pay you. And yeah, so yeah. Could my parents or people working for the company go to jail for this? This is a hypothetical. This couldn't happen to me as I don't live in the US. So in some states, there's a service where your parents or legal guardians can pay for people to come into your house and take you away. It's basically legal kidnapping. That's true. Yeah. The only examples I know where this exists are some really, really batshit crazy Christian stuff where they will steal you away and make you try to convert you by essentially force. So yeah, that's a thing. The child doesn't know what's happening most of the time does near anyone in the house except for parents. So if I, the child in this case, being taken away by these people, and I stab and kill one or more of them, what charges could I face? Well, first of all, you're a kid, so that's going to help a lot. Second of all, even if they have the legal right to do that, you don't know that. From your perspective, they are kidnapping you. So you could act on that perception. You'd be acting in subjective fear that's objectively reasonable. So in that situation, both of you would be in the legal right as far as I'm concerned. If I got to jail for killing them, so could I sue my parents for negligence? because they know I have a knife and will act in self-defense. Well, if they know you have a knife and they know you will act in self-defense, it's worse than that. They could be charged with murder, right? If they know for sure that you have a knife and you will act in self-defense, well, now they're putting some other people in a known situation of imminent harm, presumably without telling them. And so now that's worse than sue. We're looking at murder charges now. So yeah. Okay, this was a good one. Hypothetically, I sign a contract as the real Slim Shady. Let's say hypothetically I'm signing a contract and singing The Real Slim Shady by Eminem at the same time. And I accidentally write the lyrics as my name and write The Real Slim Shady, and no one catches my mistake. What legal repercussions could there be? Could I be sued for identity theft? Good question. No. Any mark you make that you intend to be your signature is your signature, which is incidentally the difference between a signature and an autograph. What's the difference between a signature and an autograph? Well, when you give an autograph, you don't intend it to be a signature. You intend it to be an autograph, right? So if you sign an autograph and it turned out you signed on a contract and somehow didn't notice, it's not legally operative because you didn't intend it as a signature. You intended it as an autograph. And there's a legal difference there. So any mark you make and you intend to be your signature counts. So yes, you can mark with X if you're illiterate, and you can mark with literally anything else. So if you want to sign The Real Slim Shady and you intend it, and well, you're not necessarily intending to write The Real Slim Shady in this hypothetical, right? But you're intending the mark you write to be your signature. So you don't even need to know the mark you're making. You just need to know that you're right. You just need to know you're signing it, right? Because you, in this hypothetical, don't know you're signing it The Real Slim Shady. But you know that you're signing your name. So did you intend to put your signature down? Did you put a mark down on the paper? Great. No, you can't be charged with identity theft. You're fine. Your hubby has signed with a happy face. See, happy face will work. Happy face is a perfectly valid signature. Let's say we're in a world where breaking terms of service takes you to jail, and YouTube changes the terms of service, and a child using YouTube can't agree to them, so a parent or child signs for them, but a child unknowingly breaks the terms of service, not knowing they were changed. Who would get in trouble? Well, if the parent can sign for the child, and so the child is bound by the contract. And this would be true of anything that the parent would have to consent for. It would be roughly the same equivalent. It would be roughly the same as a parent signing for a child to participate in, say, a martial arts class or something. You need a signature from someone over the age of 18, or they can't participate, right? So, it basically is the same. So you go to a karate studio, the kid wants to participate. You can't participate unless you get an adult signature. The adult signs for them. They break the law while they're there. They wouldn't be there but for the parent's signature, but the kid broke the law. Same basic analysis. Instead of walking into the karate studio, you walk into YouTube. And so now, same analysis. But, so the kid would be in trouble. Actually, technically speaking, both of them could be in trouble, possibly. Because you might get into, depending on what exactly the parent is doing, because unlike the karate example, there's no other parent or person there to take charge. So you might get into some sort of negligence or something that could expose you to criminal liability, definitely civil liability. If your kids behave like little shits and you're not properly supervising them, parent can be held liable for that. It's negligence, and you can be responsible, So What would happen if I kill someone at the four corners? I shot a bullet into the air at four corners, and then someone stood on the bullet and killed them. What state would they be tried in? Yes. All four. Any of the four is fine. In fact, I will answer that. In this hypo, all four would have jurisdiction. So the answer is Yes. Legal hypothetical about car kill switches. Let's say I install a kill switch in my car in case someone tries to steal it. Now, someone actually does steal my car overnight and begins driving off the highway. I wake, notice my car, and hit the kill switch. The car suddenly stops moving in the middle of a busy highway. What am I liable for? Well, that's a good question. You're probably liable for something because the kill switch immediately kills the car. So that was probably some sort of reckless behavior. So my best guess, manslaughter is a strong possibility here. Hypothetically, if someone shoves jelly beans down a parking meter and claims it fell down, the change input so they could get off criminal charges. Yeah, there would be destruction of property. You're destroying property. Yeah, you can't. And you claim you drop your jelly beans accidentally into a parking meter. How is that even possible? What kind of parking meter is there a gap that a jelly bean could fit into accidentally? Conjoined twins, great hypothetical. If a conjoined twin robbed a bank for $1 million and the second conjoined twin reports the robbery, who did it, assuming he won't be an accessory, how would the punishment go? The usual punishment would be go to jail. Well, it depends, I suppose, on the mental state of the other one and who has control of the body. Now, I'm not sophisticated enough to know how control of the body works for conjoined twins, but I would imagine that one of them doesn't have control over the other. If you had a situations where usually like the body splits or some ways, so I don't know how that would work, but if the one twin is completely unable to control the body but doesn't want to do it, then yeah, you'd have a serious due process problem because you can't separate them. You can't incarcerate the one without incarcerating the other. So if you have a situation where one twin has complete control of the body and the other twin has no control of the body, then yeah, you'd have a massive due process problem. So that would be, but I don't think that's true. So yeah. Defense of third party with a firearm. Say you're in line of a store and a man pulls a gun on a cashier and bystander. You're completely ignored and could reasonably escape a third party life. Would it be legal for someone concealed carry to draw and shoot the guy? Yes. Defense of others. Similarly, in the event of a mass shooting, if you could reasonably escape, would it be legal for you to shoot the bad guy? Yes. Same analysis. Mandatory sports. Say if in school they made you play a contact sport, but you get serious injury from it, can you sue? Well, it would depend on the nature of the injury and how it came about, because the rules of the game set the boundary. So it's possible for someone to act outside the rules of the game in such a way that would expose them to liability. For an example, there was that incident in the NFL, I think it's 2 years back, where one of the players took off their helmet and just slammed it on the other guy. So he not only did helmet to helmet contact, which is bad enough, but he actually took off his helmet and hit the other guy over the head with it. Okay, there's civil and criminal liability there. Now, I don't know if either criminal or civil charges happen, but they exist. That's definitely an assault, and it's well outside the boundaries of the game. So yeah, I mean, they could have sued for that. They could have charged for that. I don't know how that went down, but it depends how within the game you are. And the mandatory sports, yeah, it would be fine as long as you're within the bounds of the game. And there was no negligence on anyone's part. So the school would have to make sure that everyone is safe as need be. So if they made you play football without helmets and pads and stuff, for example, or they didn't do anything to absorb care, then yeah, that would be a thing. And also, as we know all too well, if it's a public school, we're talking about potential state immunity issues and qualified immunity issues. So yeah. If a dealership leaves keys inside of a unlocked car on their lot and someone decides to take it for a joyride and gets into an accident, who is liable? Would dealership be responsible for leaving keys, or the only being responsible? Well, both of them might be responsible. The person driving the car is for sure responsible, and the dealership is potentially also responsible. It depends. Did they leave the keys in a car on an open lot? Then, but the driver's definitely responsible because, they took the car illegally. Let's say someone is doing their driving test, and during it, they cause a serious road accident. The driver in training or the instructor? The driver in training. Driver in the training is the one that caused the accident. That's easy enough. If a wife of a rich guy wants a divorce and the guy dissolves his assets and hypothetically lost all the money and became unemployed, essentially ending up poorer than woman, can the court make him liable to provide his wife with previously owned luxury houses, cars, and lifestyle? Or his wife has to pay alimony as part of her assets? Well, a lot depends here on how he's doing it. Is he doing it deliberately to deliberately avoid the court's judgment? Then the court's not going to have any part of it. If he's doing it in a way that's non-deliberate, it just happened to be that way, then in most states it's a joint asset. And the joint asset's now gone. So it's not part of the equation. And to the extent they were his assets in an identifiable way, and if he did it without, attempting to avoid the court, and he's worse off than his wife, then yeah, she would have to pay alimony. In every state that I'm aware of, the alimony laws are written neutrally. I know this is a good one because it was on my Virginia bar exam. I don't remember the exact question, but I remember that because the entrustment question I remember basically verbatim. I don't remember how the question was phrased in the Virginia bar, but there was a divorce question on my written session, and all I remember about it, there was absolutely nothing complicated about it. It was as simple as a question you could possibly have. It was as simple as a question you could possibly have. The only thing that made it complicated was the genders of the people were reversed, right? So, it was the woman who had more assets than the man. And so there was nothing complicated about it except the genders were reversed. And so what's the legal answer? And I put down the legally correct answer. I don't remember exactly what I put because I don't remember the exact question, but I put down, in this situation, the wife pays alimony, which is completely correct. And I walked out of that bar exam thinking to myself, I bet there's a non-insignificant percentage of people who got this wrong simply because they can't bring themselves to put down the right answer. I was like, this is just free points for me. There's going to be some percentage of people that will get this wrong simply because they can't bring themselves to put down the right answer. Because I was like, it's a dead simple question. But it was great. Oh, this was good. Can I sue Uber for taking 7 times what I'm being paid? Because honestly, this is affecting my mental health. Hell no. Hell no. Uber has to pay you as much as they agreed to pay you. That's what they're contractually required to pay. That's true, incidentally, regardless of whether Uber makes money or not. Right? So if Uber has a really bad quarter and they lose money, they still have to pay you as long as they're in business, right? That's basically what you've contracted for. You've contracted for a guarantee. They have risk on their end. So can they charge the customer 7 times more than you're getting paid? If the customer's willing to pay it, sure. They can charge as much as the customer's willing to pay. It's free enterprise. It's free exchange of goods. It's free exchange of goods and services. Uber can charge as much as people are willing to pay. And so, Uber wants to sell transportation. And they can sell it for as much money as they want. And they also want to buy drivers. And they want to buy it for as little as possible. And if there's a 7 times discrepancy between those numbers, so what? It doesn't matter. Are you getting paid what you're entitled to or not? That's all I care about. Hypothetically, in Texas, so say you're going back to your car from the grocery store, and when the car is in sight, someone steals it and drives off. But you can still carry and shoot out a single tire, so the person cannot drive off. The person leaves your car and runs. You take the spare child and put it on leave. Would any of what you did illegal? Yes. Strictly speaking, you have just committed an assault with a deadly weapon. Now, the degree to which the district attorney is going to care in this hypothetical, who knows? But yeah, you've used deadly force to protect well, actually no, because we have to go back to that statute, remember? So because we were corrected about that. So strike that. A person unlawfully dispossessed of land or tangible movable property by another is justified in using force against the other when and to the degree the actor reasonably believes the force is immediately necessary to re-enter the land or recover the property if the actor uses the force immediately or in fresh pursuit after dispossession. And the actor reasonably believes that the other had no claim of right, and the other accomplished the dispossession by force, threat, or fraud. So I changed my answer because Texas. Yes, you can do this. I changed my answer. Yes, in this hypothetical, you could view that as reasonably necessary. So I changed my answer. This would be legal. You can use reasonable force to recover movable property, your car. Yeah. Yeah, legal in Texas. Say in Texas. So there you go. There's a modified answer for you. So I got the answer wrong, and then I got the answer right. See, we learned something today. Wasn't that great? Anytime I learn something, it's good news. Because someone cited it earlier, and I read it, and then someone said, oh, what about this? I'm like, oh, you can't do that. And I'm like, well, no, wait a second. I just read that. I got it wrong. And I became smarter. We all became smarter together. Wasn't it great? It's like, wait a second. That's not the right answer. I just read this thing. That says the other answer. Wait, I have to go back and correct myself. Yay, I became smarter. Hooray. By force, threat, or fraud. Well, how are they stealing your car but by force? Joe's mad. How else are they stealing your car but by force? It recover the property if the act used force. Yeah. If the actor used force immediately or in fresh pursuit after disposition. And the other accomplished dispossession by force, threat, or fraud. Well, how else are they taking a car but by force? So I'm going to stick with yes. No force was used to steal the car? How else do you think they're taking the car but by force? The force is against the property, but the way the statute reads, that seems to be sufficient, right? It doesn't say force against the person. It says the other accomplished the dispossession by using force, threat, or fraud against the actor. So I guess it depends what against the actor is modifying. So it depends if you say that against the actor, and also, is that still force against the actor? What exactly does that mean? I'm going to modify my thing. I'm going to say this would be likely legal in Texas. So we'll change it to likely. That would be likely legal in Texas. Can the feds charge you for the use of force? No, because you're not depriving anyone of their civil rights. But nice. So likely legal. The actor is the shooter. They didn't use force on the shooter. Yeah, so we'd have to get into that to mean, what does it mean to use force against the, yeah, because oh, it's an or. It's an or. We misread it altogether because I kept saying and. It's or. Oh, it's or. See, we continue to get smarter and smarter. A person unlawfully dispossessed of land or tangible movable property by another is justified in using the force against another when and to the degree the actor reasonably believes the force is immediately necessary to re-enter the land or recover the property if the actor uses the force immediately or in fresh pursuit after dispossession, and 1. The actor reasonably believes the other has no claim of right when he dispossessed the actor, or the other accomplished dispossession by force, threat, or fraud. So we're all good under B1. We're all good. We have become smarter. We have read the statute several times, and we have arrived at the right answer. Yay! Victory. Victory for all of us, because we're all smarter. Bald eagle. Since it's illegal to kill a bald eagle, what happens if you get attacked by a bald eagle while trying to defend yourself, somehow kill it? You're fine. You're fine. You have a right to defend yourself. Although they better really be attacking you. It's coming right for us is not going to work. Pretty big or there? Well, maybe, but that's what it reads, right? Could you be held liable for this? When putting leftover cake in the fridge with a note saying, do not eat, and you walk on your sister foaming at the mouth on the floor because you laced the cake with rat poison. Yeah, that's very illegal. That's extremely, extremely illegal. Hypothetically, is it legal to start a cult, say to worship a turning Tom? Sure. What you do as part of the cult may be less so, but yeah, you can start a cult to worship the turning Tom if you're so inclined. Hypothetically, if a SpaceX or NASA rocket blew up and killed everyone inside, whose fault is it? I don't know. If there's, yeah, assuming that there's no contract, then I guess you could be suing for negligent. You'd be suing for negligent or for wrongful death, but rocket. So I'm not so sure about that one. Why can a dog ride in the back of a truck, but I can't? Why can a dog pee in public, but if I do, it's illegal? Why do dogs get away with doing all the fun stuff and not getting arrested for it? Could I identify as a dog and get away with it all? I think you know the answers to all those questions. Covert passport. Is it legal for a business to require you to show COVID vaccination card as condition of entry? Yes. Second, if it's legal, would the business then fall under HIPAA rules to keep your medical information private? No, they're not a covered entity. They're not a covered entity. So can they require you to disclose information to them as a condition of you doing business with them? Sure. That doesn't violate HIPAA. You can give your medical information to anyone you want, and anyone can ask for anything. So if they say, here's my card, if they say, I need to see a card before I let you in, and you consent to that, well, you're allowed to disclose your own information. And once you disclosed it to this random business, they can redisclose it to their heart's content because they're not a covered entity. So, go nuts. Joseph says, you know what else dogs do in public? Good point, ma'am. Suing your own lawyer. If I were to hire a lawyer and they cost a lot of money and they seem good, but once the trial comes, the lawyer doesn't do anything and doesn't try to win, could I sue them for scamming me? Well, you can sue them for malpractice for sure. So yeah, they have to try. If they don't try, you got malpractice for sure. Hey, Attorney Tom, what do you think would happen if someone was in a bank or store and it was being robbed and there you weren't being threatened and you shot and killed the robber? Could you be charged with murder? Well, the question would be, is the robber in this hypothetical using deadly force? Because it's possible to rob a bank without using deadly force, and we've actually seen that happen. So how is the bank robber robbing the bank? If they're using deadly force at the time, sure, you're in defense of others. Go nuts. Could you be charged with murder? No. Because you're in defense of others. You're fine. If someone was attacking me and I tell my dog to protect me and severely mutilates my attacker, can I be held responsible for medical expenses? Well, it depends what we mean by, first of all, it depends how are they attacking you? And second, depends a little bit what we mean by severely mutilate. That sounds like deadly force, incidentally. Severely mutilate. So if they severely mutilate your attacker, could you foresee that? If you could foresee that, then you might have a problem. Self-defense hypothetical. Let's assume a husband and wife return from a dinner party. The wife suffers from battered wife syndrome and sees a look in her husband's face that makes her fear for her life. I believe that for sure. The husband decides to take a nap, and the woman, fearing that upon waking she'll be murdered, so she douses him in gasoline in an attempt to kill him in self-defense. Okay, first of all, this is not self-defense, strictly speaking. Depending on the state, this would be usually a reduction in the charge. So it depends on the state, it depends how it's written, but this is not self-defense. Because why? The self-defense has to be imminent. And it's not imminent. He's not trying to kill her now, and he's not in the process of trying to kill her. He's asleep. So this is not valid self-defense. That being the case, however, depending on the state, this may drop the charge or may drop its severity. A lot of states have carve-outs for this kind of thing, for battered wife syndrome. Usually it reduces the penalty or it reduces the charge by a degree, but it's not self-defense. So let's not confuse the two. He wakes from the flames while she's trying to kill him. He overpowers her and kills her and claims self-defense. Is the husband able to make self-defense? Yes, he'll be fine. She's definitely trying to kill him imminently. So yeah, I think, was the murder because the wife was acting lawfully? She was not acting lawfully. This is not lawful. It is non-lawful. It is non-lawful. Even if a jury chooses not to convict her, it's still non-lawful. Maybe a jury won't convict her. It's still illegal. Hypothetically, let's say I own a restaurant and bar. About a year ago, a brewery, I put quotes and marks because I don't brew any beer. Fine. Now this brewery has a Type 23 license, which is a small beer manufacturer. And to summarize, they brew their beer to others, in order to sell others beer. Okay. Meanwhile, my bar and restaurant loses 80% of our customer because this brewery has been slandering our name around town and saying we're upset because we don't want the competition, which is completely beyond the point. A small town needs to be more than one restaurant. If they're legally selling beer and slandering our name, what can be done? Well, first of all, it depends what you mean. What do you mean by slandering your name? If they're simply saying they don't want the competition, that's not slander. Because that's kind of an opinion. How would you prove or disprove that? And also, it's kind of true, right? I mean, all things being equal, you probably would prefer not the competition. Not a lot of businesses say, I really want that competition, man. So what exactly are they slandering? If they're slandering you, then sure. If they're illegally selling beer, then yeah, talk to the relevant authorities in beverage control. They'd love to have a word, I'm sure. The King of Casual says, how are you so cool? I don't know, man. I was just born this way, and so I can't really help it, but I'm totally cool. Yeah. Let's see if there's any other questions that popped up along the way. Not that weekly, no, not, let's see, wrong bot for questions. Any chance of following Dennis Bradley, the Connecticut senator, surrendering to U.S. Marshals for campaign fraud charges? I will cover literally anything that will get me views. All right, so I think I'm done for now. This has been a fun stream, and we've been doing it an hour and 35 minutes. How many viewers do we have right now? 68? That's not bad. I could really use one more right about now. Am I? Damn. If you're enjoying the stream, please remember to like the stream. If you're not subscribed already, why not? You should subscribe. It's awesome. And did you know for 99 cents a month, you too can become an uncivilian? It's true. Do you see the people in the chat with their names in green and the little icons by their name that looks like scales? They get that little icon because they're members of the channel and they support us. Like Joseph here or A. Henninger. They have little scales by their name because they're cool, because they are helping to support the channel. And if you don't have a little scale by your name, you are less cool. You are less cool and you have less esteem in my heart. Would you like some more esteem in my heart? You can become a member for 99 cents. Hit the join button, follow the link that the bot is giving you occasionally, all that good stuff. You can follow the links and help join. It'd be great. Until later, my friends, I hope all is well. Cheers and goodbye. Thank you, Aaron, for joining. Appreciate it.